Hello everyone and welcome back to our channel. My name is AYUSH Kumar Singh. I am a legal intern in LEXIS and Company. So today we are going to discuss contract labor under Regulation and Abolition Act 1986. So starting from the introduction, the system of employing contract labor is prevailed in most industries like agriculture and allied operations, and to some extent in service sector. The workman is deemed to be employed as contract labor when he is hired in connection with the work of an establishment by or through a contractor. Contract workmen are indirect employees, persons who are hired or supervised by contractor who in turn is compensated by the establishment. Contract labor has to be employed for work which is specific and for certain duration. Under Section 2, Clause 2b of the Contract Labour Act 1970, a workman shall be deemed to be employed as contract labour in or in connection with the work of an establishment when he is hired in or in connection with some work by or through a contractor with or without the knowledge of the principal employer. So that basically means when an employer hire a labor or a workman as an employee for certain period of time and without the permission or without any knowledge of the principal employer. That means here is a principal employer, here is a employer, and here comes the contract labor. So within this hierarchy, this employer make an hire of the contract labor at which is a root level. Basically it is a root level hiring. So it's not necessary for the employer to give a notification to the principal employer. So now moving on, who is a contractor in relation to an establishment means a person who undertakes to produce a given result for the establishment other than a mere supply of goods or articles of manufacture to such establishment through through a contract labor, or who supplies contract labor for any work of establishment and includes a subcontractor. Now let's see who is a principal employer. Principal employer means in relation to any office or department of the government or a local authority. The head of the office or department or such other office or as the government or the local authority, as the case may be, may specify in this behalf. Or in a factory, the owner or occupier of the factory, and where a person has been named as the manager of the factory under the Factories Act 1948, the person so named is known as principal employer. Now the third case is in a mine, the occupier or agent of the mine, and where a person has been named as the manager of the mine, the person so named is also known as a principal employer. And the fourth one is in such other establishment, any person responsible for the supervision and control of the establishment is known as the principal employer. Scope and application of the Act. The Act applies to every establishment in which 20 or more workmen are employed or were employed on any day of the preceding 12th month as contract labor. And the second one is every contract who employs or been employed 20 or more workmen on any day of preceding 12 months. Under the Act, the appropriate government, that is central or state government, is empowered to extend the application of the Act to any establishment or contractor employing less than 20 workmen after giving 2-month notice. The Act may not applicable to establishment of intermediate or casual nature. The establishment wherein work is for intermediate and seasonal nature will be covered by the Act if the work performed is more than 120 days and 60 days in 120 days and 60 days in a year respectively. The Act also applies to establishment of the government and local authority as well. So now let's see what is an advisory board. The central government under section 3 is required to set up the central advisory contract labor board on matter relating to admission of the act. The central board shall consist of a chairman to be appointed by the central government, the the chair labor commissioner ex officio, and third, such number of members not exceeding 17 but not less than 11 as the central government may nominate the represent that government to represent that government, the railway, the coal industry, the mine industry, the contractors, the workmen, and any other interest which in the opinion of the central government ought to be the represented as the central board. So now the last one is State Advisory Board. The State Advisory Board shall consist of a chairman or a chairman to be appointed by the state government, the labor commissioner ex officio, or in his absence any other officer nominated by the state government in that behalf. Such number of members not exceeding 11 but not less than 9 as the state government may nominate to represent that government, the industry, the contractor, the workman, and any other interest with in the option of state government ought to be the represented by the represented on the state government. So I hope you find the video informative. So please like, share and subscribe. Thank you.